Welcome to the LexIslamica video course series brought to you by the Advanced Legal Studies Institute, Islamabad. This course, Islamic Jurisprudence, is the first course of the series. If you haven't seen the introductory video to the course, it is advisable that you do so to get a better idea of the structure and nature of the course. The link for the introductory video has been given in the description below. This video, the legislative role of the Sunnah in relation to the Quran, is the 9th video of the course. Let's begin. In the previous video, we pointed out that some people are under the impression that the Sunnah is to be accepted when it is compatible with the text in the Quran. In response, it was pointed out that the Sunnah is an independent source of law and that it can establish rules of fiqh independently of the Quran. It was also stated that the Sunnah acts as a commentary to the Quran. In short, the relationship of the Sunnah with the Quran is somewhat complex. In this video, we will attempt to elaborate this relationship and simplify it so that it can be understood systematically and remembered with ease. Accordingly, the first part of this video will explain when recourse to the Sunnah is necessary and when it is not. In the second part of this video, we will identify the different functions that the Sunnah performs with respect to the Quran. Status of the Sunnah with respect to the Quran. Recourse necessary when more than one meaning found. Recourse necessary for more than one meaning. The jurists maintain that the Sunnah is the second source among the sources of Islamic law. This has been explained at length in the previous videos dealing with the sources. If the mujtahid does not find a text in the Quran with an explicit meaning for a case he has to settle, he has to have recourse to the Sunnah for the derivation of the hukm. This is called the concept of bayan. This statement means that the mujtahid has not found an explicit text, but he has found a text that is not explicit. In simple words, it means that the meaning of all unelaborated words in the Quran is to be sought in the Sunnah first. It is to be noted that the Quran is definitive, qati, with respect to its narration in its details and as a whole, while the Sunnah is definitive as a whole, but not in all its details, because many of the reports are of the status of khabr wahid. This statement means that both the Quran and Sunnah are authentic sources of law when considered as a whole. In the case of the Quran, each and every verse is also authentic and definitive. For the Sunnah, however, each and every hadith has to be examined and its authenticity has to be verified, after which they can be classified into mutawatir, mashhur, and so on, where the mutawatir is definitive. Recourse not necessary for single meaning. The Sunnah being an elaboration and commentary on the Quran, it is not required to have recourse to it, unless a Quranic text requires elaboration and commentary. If the text of the Quran is explicit in its meaning, it is to be acted upon. If it is apparent or ambiguous, that is having more than one meaning, or a meaning that needs more detail, it is necessary to have recourse in the first instance to its commentary, which is the Sunnah. In actual interpretation, it is seldom that a text of the Quran will convey a single meaning. For example, take the case of 100 stripes. The word 100 does convey a single meaning, but the word stripes does not, because there will always be questions about the nature of the whip, how high the hand is to be raised, and where on the body the strokes are to be inflicted, and so on. This refers to the verse of zina in the Quran, which prescribes 100 stripes. The unique bond between the Quran and the Sunnah. As the Sunnah is a primary source of law, the jurist has recourse to it for the derivation of the ahkam. It is secondary and complementary to the Quran. The authority of the Sunnah as a source of law is derived from the Quran. The ahkam derived from the Sunnah are therefore considered an explanation of the meanings in the Quran. Even when the Sunnah appears exclusively to be dealing with a hukm, a close examination reveals that the ahkam so revealed are based upon principles found in the Quran, and the Sunnah is merely extending the meaning of these principles or is linking up the rule with the principle. We have already said that if an explicit or express meaning is found in the Quran, no recourse to the Sunnah is required. But if a meaning is found in the Quran but it is not very clear, recourse to the Sunnah is necessary. Here we are talking about the third case where nothing is expressly stated in the Quran about the rule, and the Sunnah is laying down a rule on its own. What we mean then is that even in this case, the Sunnah may be connecting the rule to a general principle in the Quran. Elaboration of these points is given in the remaining slides. To explain the unique bond between the Quran and the Sunnah, we first claim that the Sunnah is a commentary of the Quran. The ahkam are often found in the Quran in general, undetermined, or unelaborated form. The Sunnah elaborates, restricts, or qualifies these ahkam. Examples. Examples of the Sunnah elaborating the unelaborated include 1. The timings of the prayer and their number as well as their rakahs. 2. Elaboration of the kinds of wealth in which zakat is to be paid and the amount to be paid in each as well as the time of obligation. And 3rd, the case of riba. An example of the restriction of a general meaning is to be found in inheritance. For the male, 2 shares of the female. The Sunnah explains that the murderer will not inherit. The example of elaboration is in the case of theft, where the Sunnah elaborates the meaning, saying that the property must be removed from the hirs and that it is the right hand that is to be cut. The word hirs means place of safe custody, so the thief must have removed the property from such a place or hirs. An example of a case before the courts in Pakistan for a wall clock, the wall itself was considered the place of hirs. The Sunnah links a vacillating case with a principle. The Sunnah sometimes lays down rules that are not mentioned in the Quran. These rules appear to be additions over the meanings in the Quran and cannot be considered as elaborations or qualifications within the categories explained in the previous section. Some jurists, however, are of the opinion that a closer examination reveals that these rules are an elaboration in the sense of classifying a rule under a principle. Often a case vacillates between 2 principles and the Sunnah links up the case with one of these principles. For example, the Quran has in a general way permitted all good things and has commanded the avoidance of filthy, harmful things, khaba'is. The Sunnah is linked with the khaba'is, the consumption of animals with molars and birds with claws, just as it has prohibited the consumption of domesticated donkeys. So one principle deals with good things and the other one deals with harmful things. The Sunnah in this case has classified these under the harmful or prohibited things. The Sunnah links a vacillating case with the principle continued. The Quran has permitted the consumption of seafood and has prohibited carrion. The dead fish in the sea vacillated between these 2 principles. The Sunnah linked it with permitted food. Its water is pure and its carrion is permissible. The Quran permitted a slaughtered animal and prohibited carrion. The separated fetus of an animal after slaughter vacillated between the 2 principles. The Sunnah linked it with the slaughtered animal. The slaughter of the fetus is through the slaughter of its mother. In the above examples, the principle is mentioned in the Quran, and what appears to us as an additional rule laid down by the Sunnah is actually a category of the principle. The function of the Sunnah here is the analytical development of the law. The viewer may note that these examples can easily be classified under what is said in the previous slide. The Sunnah constructs analogy on Quranic rules. The Quran sometimes lays down a principle or a rule without elaborating all the categories falling under that principle or covered by the rule. The Sunnah links a resembling case with this rule, and this function appears to be similar to analogy. Examples. The Quran prohibits marriage of 2 sisters to 1 man and then says that what is besides this is permitted. The cases of a woman along with her maternal or paternal aunt are also similar because of a common underlying cause. The Sunnah therefore prohibits such marriages too. The Quran mentions that pure water descends from the sky and is preserved in the earth. The case of seawater was not settled. The Sunnah declared that it is pure and even its carrion is lawful. The viewer may note that these examples can easily be classified under what was said in the previous slide. In this slide, however, the purpose is to highlight the mental process or analogy that the Sunnah is performing for us. The Sunnah independently lays down principles. The Sunnah sometimes lays down a general principle, the individual categories of which have been mentioned in the Quran. For example, the Sunnah lays down the principle, no injury is to be caused or borne. The Quran mentions a number of cases in which injury to others has been prohibited, like injury to parents because of their child, or injury to wives, and so on. The prohibition of injury or harm is a general principle that is formulated by the Sunnah. The individual cases of injury have been mentioned in the Quran, telling us not to injure different types of people. The Quran also says that when retaliating, the retaliation should be in proportion to the extent of the injury caused. The Sunnah elaborates meanings in the Quran. We have noted above that the Sunnah elaborates unelaborated words or clarifies the meaning when there are more than one meanings available. The elaboration is of many types. An example of this is the distinction of the white thread from the black thread during the month of Ramadan. The Sunnah explains that this is the light of day and the darkness of night. In many cases, the Sunnah assigns a technical meaning to a word when such a technical meaning is different from the literal meaning. It is for this reason that the meaning of the words in the Quran is to be sought in the Sunnah first. The Sunnah abrogates the Quran. This rule is followed by the Hanafis. Ash-Shafi does not accept this and says that only the Quran can abrogate the Quran and the Sunnah can abrogate the Sunnah. Some modern scholars deny the theory of abrogation altogether. We shall take up this topic in the next video. Thank you.